Hello everyone, and welcome to this HEC Paris virtual conference room for our HEC Insight webinar series. When joining the conference, you will notice that your microphones have been switched off. You will, however, be able to ask questions and make comments using the Q&A menu that you will find at the bottom of your Zoom window in the Zoom toolbar. The professor will only answer questions and read comments sent through the Q&A menu and will not be taking any question coming from the chat. Please be aware that questions in the Q&A menu can be upvoted by clicking in the thumbs up icon and thus prioritized on the professor's dashboard. Make sure that you keep the chat for technical questions to our team only. We would like to remind you that the webinar is broadcasted live on YouTube too. We'll now begin in a couple of minutes. Once again, hello everyone, and welcome to this HEC Paris virtual conference room for our HEC Insights webinar series. When joining the conference, you will notice that your microphones have been switched off. You will, however, be able to ask questions and make comments using the Q&A menu that you will find at the bottom of your window in the Zoom toolbar. The professor will only answer questions and read comments sent through the Q&A menu and will not be taking any questions coming from the chat. Please be aware that the questions in the Q&A menu can be upvoted by clicking on the thumbs up icon and thus prioritized on the professor's dashboard. Make sure that you keep the chat for technical questions to our team only. We would also like to remind you that the webinar is broadcasted live on YouTube. As it is 1700 p.m., I will leave the floor to Anne Michaud, Associate Dean for Pedagogy at HEC, to introduce David that's going to present today. Anne?
Thank you. Ladies and gentlemen, a warm welcome in this HEC webinar. Today, we invited David Restrepo Amariles, Associate Professor at HEC Paris, to talk about regulatory challenges and opportunities in data-driven digital transformation. David also is co-director of on research on smart law and data at IA Institute. His research analyzes the transformations of law and regulation in the global and digital society with a special focus on the fields of privacy, financial law, international business transactions, and corporate social responsibility. All these topics appear central in the transformative context we are living. So David, thank you very much for accepting the invitation to share your expertise in this webinar, and I leave the floor to you.
Thank you, Anne, and thank you to all the participants that are joining us from all over the world. So I'm very glad to share with you today some thoughts about how regulation actually poses some challenges for digital transformation, especially when it is data-driven, but also how it creates certain opportunities for that digital transformation itself. So let me start with some recent news from the last couple of weeks. First of all, a couple of weeks ago in California, a group of consumers filed a class action against Google, and they argued that Google tracks and collects consumer browsing history and other web activity, no matter what safeguards consumers undertake to protect their data privacy. Google uses to collect this data Google Analytics, Google Ad Manager, and other applications, including the Google Sign In button. Now, the type of data that Google collects goes from IP, which the IP address, which allows Google to identify some geographical location, but also the websites that you are viewing or the websites that you have viewed, and also some information about your hardware. And this independently of whether you have actually clicked on the advertisement. A second interesting case also from last week concerns a case pending at the French highest administrative court, in which the plaintiffs are basically trying to dismiss the cookie wall imposed by the French supervisor authority. And in the public hearing of last Friday, the public rapporteur, which is an independent judge, argued that internet websites have the right to prevent users from viewing the content of the website if they don't accept the cookies. Now, these two cases, in my opinion, bring about two interesting questions and challenges to start this talk with. The first issue that these two cases raise is the role of advocacy groups, both interested in these cases from the consumer perspective, but also from professional associations. If you look at the case in California, this lawsuit was brought by consumers, and the lawsuit actually is open, the class of the lawsuit is open to anyone that owns an Android device and that view a website using the types of services from which Google is collecting the data. Now, it is also open to anyone that has a Google account, but has not used an Android device to visit those websites. The consumers are claiming $5,000 in damages per user, or 3 times the actual damages, whichever is greater. And because the class is so wide, they are expecting this class to consist of millions of individuals and eventually reach damages for around $5 billion. Now, in the French case, it is not actually consumers who have brought the lawsuit to court. It is an advocacy group for professionals of digital marketing and communication, including GEST, which is one of the associations. So these groups actually have filed the lawsuit to protect the industry of digital marketing and communication. In a previous case in 2019, 2 other different associations, Quadrature du Net and Calliope, also filed lawsuits. These 2 associations are more supporting a free internet and the freedom of circulation of knowledge. And these 2 associations considered that the French supervisory authority was expanding its powers by actually prohibiting the use of the cookie wall. Now, a second interesting element that these cases concern and that you might be familiar with is the opacity of some of the softwares that are used for digital transformation. So of course you are familiar with the Google services probably in your corporations. And one of those Google services, one of the opacity, some part of the opacity that can be identified in those Google services not only relates to consumers, meaning which cookies are collected, as we saw in the case pending in California, but it also concerns corporations actually using Google services from a corporate perspective. You might be familiar with opacity in the performance of a campaign or the price of a campaign that you have with Google, or even more recently, that happens constantly, which is the change of the algorithm used by Google search. So in 11th of June, 2020, webmasters discovered as usual that basically the algorithm had changed, and now they are trying to back engineer again how is the algorithm ranking the pages in Google search. So these these cases that I just brought as an introduction tell us two important things. First is the importance of gathering in a community with similar regulatory interests, even though some companies or organizations might be competitors in the market, they might have similar policy interests. So these I'm talking about, for instance, the 9 associations that filed the lawsuit in France. But also the importance of taking into account consumer advocacy when you are deploying a data-driven strategy. The second point that these cases highlights is the importance of system accountability. Basically, companies like Google and Apple or the GAFAM in general are somehow getting away with some lack of accountability, although accountability has increased both in the US and Europe, but they might get away with some of the issues they are having. However, smaller companies might have a harder time dealing with these opacity when confronted with regulators or courts. So let me now move to the outline very quickly of this talk for the rest of the time. So I want to introduce the data tech nexus in digital transformation as a framework of the discussion. Then I will talk about the regulatory framework of data-driven digital transformation. I will highlight some of the aspects. And then I will move to the organizational structure and compliance, how this is affected by regulation. And second, the business model and innovation, highlighting every time the opportunities and challenges. So what is the data tech nexus in digital transformation? So we know that digital transformation is on the way and that the COVID-19 has increased some of the plans and speed up the plans for digital transformation. So companies that were not expected to invest in the next few years are actually thinking now of investing in digital transformation. And there is some expectation actually that the investment will go beyond the 2.1 trillion that was expected for 2021. And much of these investments are going to either technology or to improving the quality of data, which has been identified as one of the elements hindering digital transformation. So how does digital strategy play out? It's important, just as again as a framework, how digital transformation plays out in the general corporate strategy. So digital transformation are programs that do not only affect processes, they also affect products, sales, and when they are very large, they might even affect the entire business model. So basically, digital transformation projects cut business strategies. And because they cut across business strategies, it is important that they also remain in line with these business strategies. So it is at the same time a transversal strategy that needs to take into account the specificities of the specific business strategy in which it is having an impact. So it clearly cuts across the corporate strategy. Now, independently of whether with industry we are talking about, of course, some industries might be more affected by one of these components. We can identify 5 components of a data-driven digital transformation. So I'm placing here in this slide data and technologies at the center, because we are talking about a data-driven digital transformation in our case. And the first issue that is important as a component of this first part is data governance. I will come to that in detail a bit later, but basically this is about what data you have and how are you organizing it to make it accessible and exploitable for the entire company. A question related to that is, what is the technology that is going to be used, and how does the company positions itself in relation to the technology? Is the company actually developing a new technology by itself, which might bring additional benefits, for instance, having a trademark or having a protected product, a copyright product, but might also increase risks if actually the development doesn't really turn out well? Or we'll rather choose some standard solutions in the market, which actually require less tech competences in the firm and might eventually provide a similar benefit than developing it internally. These elements have to really be thought in relation to the maturity of the company to handle data and technology. Now, in addition to this technology and data that I'm placing at the center, you have 2 elements that influence the strategy. First is how is the strategy going to impact the value creation? Is it going to change the type of products that you are offering? Is it going to improve them? Are you expanding the portfolio? Is this expanding the portfolio of products too far beyond your core business, which might then require new competences in the company? So point to take into account is, how is this data strategy going to impact the value creation that your products and services currently have, and how expanding it might actually have a bear on the competences that you need within the company. And this is exactly the point number 3, because the transformation, as I said before, cuts across a strategy, across departments and business strategies. You also need the leadership that also across those departments and business strategies. Now, particularly in this case, it is important that that leadership has some competence with data and technology. So it is not only about getting a leadership across business strategies and across departments, but also getting a leadership that can actually lead a project that relies heavily on data and technology. Now, the driving force of this process in which data and technology is placed at the center, and in which value creation and structural changes have been considered, are the financial aspects. The company at some point will have to face the question of whether this transformation is urgent and how it will be financed. Because of course, the financial aspects are at the same time the driver of the digital transformation, decrease cost and increase profits, but also a limitation. How is our current budget going to fund this transformation? So this first vector of change is the traditional conception, right? You have the financial aspects in the center, driving the force of the transformation with technology and data, and taking into account changes in value creation and structural changes. Now, it is sometimes forgotten, and this is why I'm adapting actually this framework that is proposed by Matt et al., are the regulatory aspects. How do you factor in the regulatory aspects in your strategy? So in many cases, the regulatory aspects are seen as an opposing force to digital transformation, or at least in a sort of tension with digital transformation. Many of you may be familiar with legal departments or lawyers being called Mr. No, because the answers to the questions are generally is not possible. But I want to show you in this case today that actually by taking a transversal approach to data, but also a holistic approach to compliance, actually the regulatory aspects can be also a driver of change and creating opportunities. So let me take a dive into the data and technology aspects, right, before moving into the regulatory framework. So we know data is critical when it's placed at the center, as I am placing it here. When it's placed at the center, we have to understand better the nexus between the data and the technology in the transformation strategy. And the first thing we can identify is what is data useful for. And there are classically three elements for which data can be used. One is to improve the efficiency of processes in the company, to identify those processes that require some improvement, whether through automation or optimization. Also to improve the understanding of consumers, either by market segmentation or by identifying actually new business opportunities for those clients. And the third is innovation of products and services, more generally speaking, which actually can impact the business model and for which I will show you a specific case study today. So without actually digital data capabilities, these cases will fall into mere IT operations. And this is independently of whether you use structured data or unstructured data. So you might be familiar with structured data, which is typically relational and is contained in most databases of corporations. But you can also use unstructured data, which is all the other data that might be neglected within the company. And actually, this data, it's pretty important when you are going to connect it with the technologies, because the use of new technologies such as artificial intelligence or IoT, it's very much about big data and very much about unstructured data. So once you have identified the type of data that your company may dispose of to undertake the transformation, you want to identify the right technology to extract value from that data. Whether to mine the data, for instance, if you're using data mining from texts, so this is a method of artificial intelligence, or to understand your data through analytics, or simply to process actually the data using cloud services. So identifying the correct match between the data that you have and the technology that will be exploited. So the first takeaway at this stage is adopt a data mindset. And this basically means that we might be accustomed to see a whole set of information or things within the company, documents, contracts, surveys, key performance indicators, reports, images or sounds as just being pieces of information. But they are actually the basic fuel that requires the engine, which is the technologies that can be used. So once you adopt this, when you take the approach of sometimes called datafication, which is seeing things in forms of data, you might be able to start looking at how you can improve products, services, or efficiency in your own processes. In Netflix, for instance, started using the viewer habits to create films that would actually fit the interest of consumers. Bimba, which is a spin-off construction company in Latin America, started using information from SAP and contracts to determine supply patterns in construction projects and to predict the need of materials in those construction projects, but also to create the marketplace for that. And you all know probably the Amazon case in which they used 10 years of CVs that were slipping in the archives of the company to improve their hiring process, even though we know that this process revealed or was based on data which contained certain biases. Let me now move to the regulatory framework at this stage. So to see how basically these elements connect with the regulation we have today. So the first thing when we look at the regulatory ecosystem is we want at least to look at two legs of this regulatory ecosystem. The first is the regulation itself, whether it's from the state or from non-state devices. And the second part of the leg is what are these regulations regulating? Are they regulating data, processes, technologies, assets, or services? Now, the importance of having a wider perspective on regulation, and not only from the state, but also from non-state, is because it is an illusion actually to think that only state regulation is relevant for the company. One reason is that state regulation in the field of data and technology, it's on the making. There are initiatives in the European Union, in other countries, as you probably know, in the US, only California has a recent Privacy Act. And in Europe, the regulations on artificial intelligence or the digital market are under discussion. So there is a certain amount of gaps in the regulation, and state law is not enough. But the other reason why non-state devices are important is because if you don't look at them, you basically deprive yourself of instruments that can help you shape the regulatory environment in which the company or your processes or products are deployed. And these non-state instruments, I will just explain them in a second. So let me take you through two interesting examples at this stage in terms of state regulation: consumer protection and competition. I will talk about data protection in a second, and these consumer protection and competition are more relevant for businesses. So from consumer protection perspective, the objective of consumer regulation is to protect consumers in business to consumer relations. Now, and specifically for our case when it concerns data. In a recent case in France decided by the Parisian court, the court found that Google's terms and conditions contained abusive clauses. The court found that basically Google was presenting services such as Google Maps or Google Documents as being free services. But the court thought or considered that these services were actually market services that were paid by consumers with their data. And therefore, they could not be presented as free service because with this data, the company was extracting value, which was the targeted advertisement they were performing afterwards. So this shows how this consumer protection regulation, actually that is common to several European countries, empowered consumer associations specifically in France. So for companies, when looking at consumer protection, it is important to understand what's the role of advocacy groups of consumers, as we also saw in the first case, in a specific jurisdiction where strategy is being deployed. A second element is competition, which includes different aspects. But let me focus on one point. Because we have this data-driven data ecosystem, some anti-competitive behavior can come from data practices. In 2019, the Federal Cartel Office in Germany found, for instance, that the vast amount of data that Facebook has constituted a monopolistic position. But instead of giving a fine to Facebook, it actually restricted some of the processing activities that Facebook was undertaking. This is an interesting decision because while the cartel office found that Facebook was incurring into an anti-competitive practice, this data itself was not contrary to GDPR. So we have here precisely the interaction in the ecosystem in which this practice will be legal under GDPR if the data is actually collected and used for the specific purpose, but it is considered in this specific situation to be a monopolistic position. Now, the self-regulation tools and co-regulation tools, as I explained before, allowed the companies to shape their environment. Self-regulation tools bind the company with itself. For instance, a privacy escalation policy, it's a policy that will apply within the company and that would help the company streamline the privacy processes that or privacy requests that emerge within the company. Core regulatory tools are tools that bind the company with other actors, whether they are sectoral or other companies or the suppliers, and are very efficient to define more concretely the consequences of state regulation in a specific sector. So there is also an opportunity for companies here, especially, for instance, considering Articles 40 to 46 of GDPR, to shape to some extent the specific practices in their domain. Now, how these regulations play out in the objects of regulation. So there is today, to give an example, there is today a complexity in the data supply chain, meaning there is a company collecting data and processing data, but this process is also supported by a set of subcontractors, in some cases with long chains of subcontractors. Now, it means that some companies collect the data, others store the data, others produce analytics on this data, others produce visualizations of this data, some others use it for decision-making, and all these companies are linked together. So having a perspective on how is the regulation impacting the different processes and elements of the digital transformation is also important for the company to take into account. So I would say the takeaway from this section, 2 points. First is you better pay attention to your core regulatory and self-regulatory instruments as much as to state regulation. And the second is that basically data regulation is not just a bulk of state prohibitions, but can also be shaped by actors that participate in a sector or in an industry. I propose, Anne, if there are any questions, that we take some intermediary questions at this stage.
Yes, I think there might be something of interest because you actually gave the several examples showing the variation in the regulation that happens across countries. Yeah. So can you tell the impact on businesses and whether that could hinder the expansion of businesses across countries?
Yes. So thank you, Anne. So that's an interesting point. In fact, these regulations, so like in California, you have the California Privacy Act. Other states do not have regulations on consumer privacy at least not in the same way. And in Europe, there is a trend towards Europeanization of some of these matters, especially with the creation of the digital market, European digital market. So I would say that currently there is, to a certain extent, a gap of regulations in many countries, and that is why the tools such as a code of conduct are fundamental in any expansion strategy of a company. Companies do not like to operate in a vacuum, in a legal vacuum, or may not like to operate across jurisdictions with terribly different standards. So using self-regulatory or co-regulatory tools to frame the standards under which a company will undertake activities in multiple jurisdictions might be a good practice for companies not to be stopped by these, let's say, regulatory asymmetry among certain jurisdictions.
There was one question probably related to this from Asta asking, could there be any change in developing countries with respect to those regulations?
Yeah. That's a very interesting question. It's an interesting question that's a different level. So with developing countries, there is an ongoing discussion in terms of copyrights, knowledge transfer, and also data. There is a lot of data that is collected in developing countries, and this data is subject in many cases to lower standards of data protection. So some companies have been training and deploying some of these instruments or some of their products in these countries because of the richness and wealth of data and the quality of data. So I think there is probably, again, a not, the level playing field needs to, it's not homogeneous, I would say, across countries. And in developing countries, but also in actually developed countries, there is still significant gaps and significant vacuums in terms of regulation. And I guess companies face, and it's my experience as well, companies face in developing countries similar challenges in terms of the regulatory framework.
Yes, thank you, David. I suggest we just go to your next part and take some more questions at the end, because I just want you to have time for the last.
Perfect. Okay, so once we have this first framework, let's dig a little bit deeper on how this framework again, it's different, varies across jurisdictions. There is some convergence to some extent, as I will show in a second. There is some convergence in some issues. How this regulatory framework affects the company. And a first dimension is the organizational structure and compliance. When you look at the issue from the perspective of data, a good practice could be to follow the data cycle within the company, meaning the collection and the processing and the use of the data that can be automated or not. So if you look at the data cycle, how the data is collected, how it is used, and for what purposes it is used at the processing level, and how it is used for decision making, you might be able to identify the tools that need to be deployed and the persons actually that need to be either hired or added to a specific team. So if we take, for instance, the 7 principles of GDPR, I'm not going to go through the 7 of them. Has been quite a lot. There's quite a lot available on principles of GDPR. But let me take just one, right? That is interesting, which is to keep the data to the original purpose. Okay, this basically means that when a company is collecting the data should be collected for that specific purpose. When the purpose is not valid anymore, the data should be removed, as in application of Principle 5. Now, what is the implication of this for the organization of a company? If you think about how data is collected, imagine that customer services collect certain data to respond to consumer requests. But if you have not foreseen that this data can be used for marketing purposes from the beginning, the data cannot be used for that. This basically means that at the moment that data is collected, you have to think about a strategy at a corporate level for data collection and not necessarily at a project level, because it basically means you are wasting a huge effort in collecting this data that will not be available for the rest of the teams within the company. So this is an example, a classic example of how the regulation requires to think the organization of data management within the company. But probably the most important aspect of GDPR that affects corporations is accountability. Basically, with the data protection regulation, companies are liable for ensuring compliance with GDPR. This basically means that companies are not only liable for a violation of the regulation, but are also liable for not implementing within the company technical and organizational measures to ensure they comply with the regulation. So this is clearly an additional burden that can go from appointing a data protection officer, documenting every data processing activity, ensuring that there is data protection impact assessment whenever data or technology is used, and all this has to be documented. So these burdens and these type of provisions and regulations raise certain challenges for companies, and identify at least 5 challenges that might be relevant. The first is that compliance with data regulation has become decentralized. This basically means that it is not one person within the company that deals with data protection, but that is every team undertaking a project when there is no one specialized in regulation that has to be concerned with the protection of data. This happened also in other sectors. In the financial sector, this happened with money laundering regulations, with economic sanctions and corruption, basically putting the burden on every team within the company to ensure compliance. The second and third are related, is a regulation overload. There is a huge amount of regulations coming, and we mentioned that when Anne raised the question, is there is a lot of regulation, especially if the companies operate across jurisdictions, either from state and non-state devices. And there is also information overload because these regulations require a whole set of documents and processes to be reviewed. And it's sometimes contradictory because they come from different jurisdictions. So there is also not only a regulation overload, but also an information overload. The fourth point is the complexity of supply chains. As I explained earlier, especially when they concern data, data flows in supply chains more or easily than goods. This means that a lot of the processes in the data supply chain happen in different places of the world by different organizations and companies that are at the head of a processing activity. Let's imagine the company that is collecting the data and then wants to use this data to draw insights from their consumers or to design a new web page for online sales, might not be able to control the entire supply chain. This means who is storing the data, how they are storing the data, are they respecting standards for data storage? Is the data not being shared with third parties? So all these standards are difficult to control by the company at the top of the chain because the supply chain is complex and long, especially when it comes to data. And the last point is that data management practices are segmented. I also mentioned that earlier in the example of collecting data for consumer services, but not for marketing purposes. So this requires also to view the process in a transversal manner. So these challenges, although I have talked about data compliance, brought us to not to think from a strategic perspective, not only how the company can comply with the regulations, through compliance, meaning through its internal processes, but how can it ensure while complying, right, because this is the main objective, the business objective, while complying, that the data is available, usable, that there is integrity, and that it is secure within the company. And this is where the shift from data compliance to data governance happens. And this is where the organizational structure is key. So how can this shift towards data governance take place? First good practice is to invest in legal and technologies and compliance technologies. This means that teams that do not have particular legal knowledge will be able to rely on technologies that at least will flag key issues or problems with the use of data or with the use of technologies, allowing them to focus on creating value in their project and not being concerned about problems of liability in deploying the process. The second is to review reporting lines within the organization. And this involves also providing us an important role for data protection officers, not only as the, let's say, the data policeman within the company, but also from the strategic view of deploying the transformation strategy. The third is to implement company-wide trainings. And this may sound business as usual, but the important thing here I would highlight, it is not just a training about legal concepts. It is not a training about regulation. It is also a training about leadership, for instance. We've seen in previous cases, like in HSBC, in the HSBC case before the US authorities, for violation of economic sanctions, that internally the teams reported, for instance, that there were violations of the economic sanctions, but they lacked some skills and lacked leadership to make this reach the right persons and in the right way to stop these violations to continue happening. So it is a training, not only in terms of legal notions, but also in terms of leadership as well. The fourth is to include privacy as a variable in every project, and ideally from scratch. this is just the application of what is called privacy by design, meaning the process needs to be designed in a way that it takes privacy into account in order to avoid that at the moment of scaling the project or the product, you will be facing legal issues. And the fifth is to use code of conduct. I also mentioned that earlier, but codes of conduct allow the company to adjust regulation, not to change regulation, but to adjust regulation to internal needs, to make it comprehensible and adapted to what the actual operation of the company is. Let me now take for this last 5 minutes for the last point, which is business model and innovation. And here I would like to present a case study. So in early February, for the first time, we got information about the revenue of YouTube advertisement. 15 billion, which is a subsidiary of Alphabet, which is Google's company, or it's, let's say, the parent company of other Google companies. And YouTube ads reports 15 billion, which is the second highest revenues of all the Google subsidiaries or Alphabet subsidiaries. Now, this is surprising because it was the first time that it was published, but it's also interesting when we try to understand the business model that led to that revenue from YouTube ads. So this comes, and it's one line of understanding, is this comes in part from the Digital Millennium Copyright Act in the United States. In 1998, the act was adopted, implementing the procedure of notice and takedown. The notice and takedown procedure basically means that a content provider, an internet service provider, in this case, YouTube, would be liable for violation of copyright if it is notified by the copyright owner that the material they are hosting online is copyright protected, and they don't disable the access to that content. So it's a notification from the copyright owner and a takedown procedure from the internet service provider. Now, this was fine until basically a lot of notifications started to arrive to Google. So if you look here, more than 4 billion copyright requests have been dealt by Google, and many organizations have actually specialized in providing these copyright notifications. In particular, if you look at Rindel, and Rindel, they have designed an entire industry around algorithmic notifications, basically identifying automatically through algorithms when is there a violation of copyright material, and issuing automatically a notification. As you see in the graph above, basically Google was facing, up to 2017, there is no more updated data on that, was facing around 23 million notifications a day. So here comes a crucial issue for YouTube. If YouTube doesn't delist the content that is notified automatically by these algorithmic systems, they might incur in liability. But if they disable the access to all this material, which might not be violating copyright, maybe, if they disable this material, well, this will be a serious challenge to their business, because it means that they might be actually taking out a lot of videos from their platform, making it maybe less attractive also for consumers. So Content ID came as a solution to address this issue. So Content ID basically is a software developed by Google and YouTube to scan automatically the content that is uploaded on the platform and verify whether this content is copyright protected or not. Now, if so instead of waiting for a notification, they actually implemented themselves the verification of the content. Now, this might be counterintuitive because if they have not been notified, they don't have the necessity to disable access to the content. Nonetheless, the purpose was not only to identify violations, but was to create a new business model behind. Basically, by identifying copyright material or allegedly copyright material but content ID, the software automatically proposes two alternatives: either a notification and procedure of takedown, or the monetization of the violation. And this monetization of the violation basically means that the copyright owner, let's say Universal Music, enters into a licensing agreement with the content owner, is the person using a copyright material and uploading it online. So this reduces almost to zero the transaction cost for entering into a licensing agreement. Now, but what revenue are actually these two sharing? And that revenue that they are sharing is the revenue of advertisement. And this is very much what is behind, this is very much what is supporting from a regulatory perspective, the business model of Google based on licensing agreements between content owners and copyright owners and advertisement before the videos are run. Now, this is not the end of the challenge, because a court in 2015 said that before notifying or before using the copyright, the content ID material, a tool, the company, in this case, YouTube, should consider whether the material is not covered by the fair use exception. This basically means that, as we all have seen, you have the right under the fair use exception to use copyright material, for instance, for a parody, to create a parody or to comment, to do critical comments on an existing material, even if the material is covered by copyright. So if it is covered under fair use, the content cannot be disabled, except that under the content ID way of working, this material will be disabled if it is identified by the tool. So the court said Google, in this case YouTube specifically, needs to implement the fair use exception before it disables or actually notifies that the video violates. This is a huge technical challenge for the AI team of YouTube. So they created an alternative tool. I will pass on that, but you can have a look at it. It's called Copyright Match. And also in Europe, they are facing similar challenges, because the European copyright and related rights, the digital single market, provides not only that the copyright, the platform is liable, but that it has to check and ensure that they have the authorization of the copyright owner before the material is uploaded, right? In the US case, we are in a notification system. Here we are in a before the content is uploaded, which basically means that platforms like YouTube need to implement mechanisms to verify that the videos that are uploaded are not violating copyrights. Again, you see the transformation based on this regulatory burden that was imposed on Google into a new business model, and then emerging new challenges. Last point, and I will conclude with this, is the data portability. So this is a good example of the opportunities that are created by regulation. Data portability is contained both in the General Data Protection Regulation in Europe and in the California Consumer Privacy Act. Data portability basically means that consumers have the right to request their information in a machine-readable format to transfer it from one company to the other. Now, this basically means that companies need to think about how this new provision of data portability affect their strategies if they are moving to a data-driven strategy or they are moving or implementing a data-driven digital transformation. And there's two ways of thinking about data portability. One is data from a competitive perspective. And this has two possibilities. One is defensive data portability strategy. So this is, think about how you want to protect the data you have from your consumers, not to, or to prevent them to some extent that they take these data to another company. An example could be, or although very radical, would be to erase all personal data and keep only aggregated data, which doesn't have to be shared. Another possibility from a competitive perspective is an offensive data portability strategy, meaning how do you get data from your competitors? And this is interesting because if you think of a service like Amazon Prime for videos, Amazon Prime could, for instance, by thinking on this provision, establish a strategy to attract new consumers to their platform by providing a 6-month free trial or by providing a huge discount. And as far as consumers take the data with them. And this would allow the Amazon Prime not only to gain new consumers, but to better target the offers they are going to make to those new consumers based on the historical data that they are bringing with them. Another example of data portability is cooperative data portability. This means how can I collaborate with other firms to establish, for instance, new services or cross-sell. This means that you will be able to benefit from the data that consumers have in a different company. Imagine the case that Spotify could partner with a company selling tickets for concerts. So basically, they could Spotify could allow or request its consumers in Spotify to share with whom they buy information, from whom they buy tickets for concerts, and include this service in their platform. At the same time, they will share with the sales ticket company the information of your streaming music, the music that you actually stream the most. And this will allow the company selling tickets to sell you premium tickets, early bird for your favorite singers when they come to town. So this is a comparative way of seeing data portability. This is a very recent provision in Europe, 2018, and in the US, 2019. So there is still huge time to improve these processes. And here is the concluding slide. So I have talked about how to take advantage of this. And I mentioned at some point earlier in the presentation, adopt a data mindset. Second point, map your regulatory ecosystem, state and non-state. Review your data architecture or data governance. So not only to comply, but to extract value from that data, cutting across departments and cutting across business strategies. Review your team compositions. Again, leadership in these projects involve the need for knowledge in technology and data. So you may want to review how are your teams organized. Review workflow and silos in the organizational structure. Today, a lot of AI committees are involving the risk officer, the compliance officer, financial officer, legal officer, and several officers in the company to think about the implication of deploying an AI technology within the company. And the last one is, don't think about digitizing existing processes, rather redesign them to take advantage of the data, as I gave you an example with the new supply chain developed by Bimbao. For me, the conclusion of this talk is that a digital transformation strategy that incorporates decentralized data compliance and transversal data governance is more likely to favor innovation and new business opportunities in the current regulatory ecosystem. Thank you very much for listening and happy to answer to your questions.
Yes, thank you very much, David. Actually, maybe there is a first question that is very much linked to your conclusion. So I will start with this one, and we have time for a few questions. So I'll try to cover as many of them as possible. There's one from Bogdan on data and innovation, and he's saying, actually, AI relies on past data. So is there a risk that in fact data becomes one of the biggest conservative force because it relies on this past data? So if we are to judge future innovations and probability of their adoption by consumers, it might be that past data is in fact a very conservative vision.
Right. Yeah. I mean, this is a fantastic question. And I think that it touches on the creative potential of artificial intelligence. This has been sometimes highlighted as one of the limits of technology is, can the technology be creative? Now, there is an interesting example in the fashion industry. So in the fashion industry, there is a tendency now that that data is mined from different social networks and to see what are people wearing, and specifically certain types of people are wearing, and to try to extract some tendencies out of this information, or sometimes new products that are put forward by leading fashion companies to see what are, let's say, the patterns, for instance, of these new products, and generate a new offer for another company. And this example is interesting because to some extent it depends what is the data that you are collecting. Are you collecting data of existing, for instance, existing collections or past collections, or are you trying to identify, for instance, how collections change to one another and try to predict what is the new trend based on trends that are happening, right? So you have different ways of aligning your data, but I agree that this is the data strategy will not replace creativity.
Okay, so probably I'll go for the most voted questions, right? There was one about the situation in China and saying that Google and Facebook are banned in China. So how will digital marketing, data collection and regulation affect China, which is now one of the richest countries in the world?
Yeah, so that's also a very good question because I didn't talk about China. And of course, one of the reasons I didn't talk about China because the time frame was limited, and China has such a huge amount of particularities, especially because it's a market where there is a strong actor, which is Alibaba, in different areas. But of course, there is the interest of Chinese companies for entering this market. So I would say that in terms of data, just maybe to limit their response to that aspect, although the questions are way broader than that, relate at this stage for many external actors in the reputation impact that can have deploying certain business strategies in China vis-a-vis consumers in other areas. So we have had cases previously in California, but also in Europe, in which, and actually know that there are servers with European and American data in China. But once some strategies and some more visibility is gained by American and European companies in the Chinese market, there is a certain challenge that is going to be faced by these companies. Is how are they going to align that with certain consumer expectations in their original markets? And I think this is maybe one of the issues I would highlight of when these companies that absolutely need to enter into that market are going to do it, and with force, is how are they going to match that with the expectations of consumers in relation to privacy in their original markets.
Okay, thank you, David. And we'll take a last one. It's from Mohammed, who says, so far you've looked into how entities regulate data. However, as more and more organizations migrate their operations onto cloud-based service providers, what regulatory considerations should these organizations take into account?
Yeah, that's also a very good question. Oh, fantastic. So indeed, I look at what I would call regulations on text. Okay, so this is regulations that say to companies how to do it. to some extent. But what I didn't talk about is more sort of infrastructure regulation. So this is at operational level. And this is another whole topic. It would be great to discuss this, is what are technical standards. For instance, there is a different set of blockchain parameters or specifications in software specifications that have proven more efficient, for instance, to avoid certain data to be transferred to a third party that should not access the data. So here at this level, today, what we have are technical standards that are being developed by technical standards associations in different countries, and we might expect some convergence. But the operational level, the very operational level of these technologies is highly under-regulated today.
Okay. Well, thank you very much, David. I think for time reasons, we are going to stop here. So I wanted to thank you very much for sharing your insights, because I think these topics are very much in the radar of most companies today, including us, actually. So that's a very nice topic to listen to. Thank you to all participants for your participation today. I wish you a great summer, because this was our last webinar of the season. You can watch again this webinar and all the others that we had previously on YouTube. And we will start a new series in September. So new context, new theory, and new topics. So thank you very much for following us, and see you back in September.
Thank you very much.